kind of reliefs, especially therefore impossibility of entire globe has observed such a kind of scenario in the business world. Today, we will have understanding of impact of COVID-19 on performance contracts, especially governed by the Indian law, and what alternatives we have, and what are the things which are suitable for the business world in this scenario. On the other hand, the pandemic has also, and this has happened because due to change in the business outlook, concerns the crunch, due to reduction in the lending abilities of the banks, reallocation of funds, closure of international borders, and arrangement of the surplus funds. So we also have the clarity on especially possibilities that we have because to stay on mute, and we will have a live session for around 45 minutes, and then we will take question answers. This will take around 15 minutes, will be open for everyone. So you are open to pose any question that you have on the chat box. So we will try to take almost. Having said that, I will join all the participant valuable time that you have for the discussion. I request Deepti ma'am to share her views on the topic. Thank you.
Good noon to all of you. I hope I'm audible to all of you. Yes? Okay, great. So first of all, I would like to thank Professor Amit Kashyap, who is the head center of corporate studies of Nirma Law University, and of course, yeah, and Varun Akkar and all his classmates who have been wonderful in arranging such kind of webinars, especially in the COVID scenario. So I'm sure it would be enriching to all of you. I've just heard that, and I've also knowing about it that they have also conducted the session on insolvency. So it's very great that these kind of topics are being debated, discussed, because these are the buzzword in today's world of this COVID scenario. The entire industry is going through all this. So it is also a great opportunity for law students like us who can understand, interpret, and further see the jurisprudence over the law which is being developed on the concept of force majeure and, of course, the doctrine of frustration. So with this, I would like to start my presentation. I would also like to thank all the participants also who have been keen and enthusiastic on the Sunday afternoon to join this webinar, and the wonderful effort taken by Professor Amit and Varun and team. So thank you all of you also at the first instance. Now to start with, I would like to take you through some scenarios of the COVID-19. Of course, it's not been new to us that what has COVID created us. Yes, physically, it has been a tremendous issue. Then also, yes, social distancing, everything is there. But the kind of thing which has definitely affected us is the lockdown by the government. So this lockdown by government has not only created, of course, it is for the safety of all the citizens of India. And it is not just that we have faced this in India. It has been all over the world that the lockdown was implemented by the respective countries. But yes, it has created the issues when we see it from a commercial contract perspective. So that has definitely created the issues in how the contracts have been discharged, how the contracts, the rights, obligations of the parties involved. So today we are going to see what are the remedies, what are the scenarios, what has the court have held, what is the jurisprudence on all this, so that it becomes easy for us to understand and interpret that how going ahead we can also be vigilant about it. Because there have been the scenarios now, if we see it from an industry perspective, what things have impacted is, yes, the lockdown, then the social distancing, Then, of course, there was a work from home which was being implemented by most of the IT companies. But of course, in case of manufacturing companies, this liberty is not available. So most of the staff could not resume, and therefore the production which we saw have definitely hampered a lot, apart from the essentials. So yes, essentials, pharma companies were up and running, but most of the manufacturing sector has got a big hit. Say even the hospitality industry, the travel industry, they've faced a tremendous hit due to the lockdown, social distancing, and since they can't work from home, these businesses have badly been impacted. Plus, what we see is, unfortunately, this is not end of the COVID scenario. There is also still uncertainty, like the cases are growing, so we don't know when our area can go into a containment zone and how things are going to move ahead. So there is still uncertainty when it comes to the contractual obligations, whether a party will be able to fulfill or not, whether a particular area is in a containment zone, a factory, or likewise. So these things are going to be a challenge, and these things are going to be need to be discussed, deeply thought through. And of course, like it's being given to us that there might be a second phase of COVID also. So even that is what we can't rule out until we have got a vaccine, and we hope all get out of this scenario. So in the light of all these scenarios, the commercial contracts become very, now what impact it creates is what I would like to highlight over here, that okay, given these scenarios of COVID, what impact it has created on the contracts. So if you see, the performance of the contracts has become difficult or impossible. So say, for example, if it's a goods manufacturing, a kind of a raw material supplying industry, say cotton for that matter, or say, for example, if it is a chair manufacturing industry. Now, chairs is not something an essential as of now. So if that order has to be placed, then of course it is not being possible that the order was being fulfilled, or the obligations under that order of supplying 1000 chairs to a particular company was becoming difficult. So this is what becoming the performances are becoming difficult in the COVID scenarios. Plus, there have been commercial hardships as well. Like, for example, the transportation is an issue, or till the time only railways were supplying cargo. So if the transit is used to happen, plus there is a issue about labors, like the labors can't come to the factory and work. So there is also a concern that how the production is going to happen. So all these scenarios are creating created because of the COVID. Now, because of the lockdown, again, what we see, the contractual obligations, there is a delay in performance. Now, the same example, if I have to take, like 1000 chairs are to be distributed on, say, 10th of May was the scheduled date before lockdown, when everything was negotiated. But because of the lockdown, this 10th May delivery is not possible. So what is going to happen is, whatever is being committed prior to COVID may not be fulfilled, or the obligations may not be able to be fulfilled because of there was a lockdown. So in such a scenario, there would be delay in performances. So delay in performances of the obligations which have been agreed by the parties in the contract. Plus, what we are also seeing is most of the companies are unfortunately getting bankrupt because their expenses are not stopping anywhere, like they have to pay their rent. Plus, we are also going to discuss about the MHA guidelines on the labor laws and payment to the wages. So all these things definitely are there. So your expenses are not going anywhere, but your top line, or what we call is the sales, is not happening. So if you see, major automobile sector reported zero sales in the month of April, right? So here there is no sales, there is no income to the company, plus there are payment obligations. So due to which, what is happening is, unfortunately, many companies are also facing financial hardships. So they are also looking out in terms of how this financial hardships can grow. So even if they have committed a particular contractual obligation, like say, for example, they have decided that, okay, these goods will be supplied, but what about the working capital? What about all these things? So the financial hardships is also one of the concern in the contract. And of course there is some kind of unjust enrichment also, like we are also going to discuss about what happens in the lease scenarios. So say for example, I have an office in particular area. Now I'm not able to go because of lockdown over there, but I have to pay the rent. So here I have to pay the rent which I've agreed in the lease contract, but I can't go. So there is, I'm not able to enjoy the leased property, but I have to pay the rent. So these are all the concerns which are coming up when it comes to contracts. Now, like we know, there are various types of contracts which are being executed. So it can be a vendor contract, it can be a supplier contract, like you are the customer, or you are providing to your customer. So again, it can be of goods, it can be of services. So most of the areas of service sector, fortunately, have not been beaten up by COVID, because they are able to work from home to the extent possible. So mostly in the service industry, it has not that impacted as it has impacted in the manufacturing industry. So these kind of things, so be it any lease contract, so these contracts and the nature and how the principles of law come into picture is what we are going to now further discuss about it. So if we see what are the issues when we see in the contracts. Okay, we understood COVID, we understood that what are the concerns of the companies, be it manufacturing or be it a service sector. But the thing is, okay, we understand now how we are going to implement those in the contracts which we are going to have, or how are we going to seek remedies when it comes to the contracts which the companies might have entered into. So typically, first I'll discuss what are the inabilities why the companies may not be able to take advantage of the contracts which they have, and the reasons for it. So if you see, unfortunately, there are many companies or the industries where they have what we typically call this as boilerplate clauses. Boilerplate clauses is like without any negotiation, without any thinking, they'll just put the standard clause. And like we all know, each situation demands a different set of conditions, and contracts ideally should be very well drafted, and it should be negotiated between the parties. But the problem is, we have many a times the companies use just the boilerplate clauses, the standard template with all the customers, irrespective of whatever is the nature of transaction, irrespective of whatever is the size or amount of the deal involved. So that creates a problem, because it is not a negotiated contract where you know that, okay, this is the obligation, this is the right of the parties. So it's like a one stretch for all. So that creates a problem. Another thing is, and which we are also going to further discuss, sometimes there is no mention of force majeure in the contract. So if such force majeure is not there, is what we're going to further see, that what if it is there and what if it is not there in a contract. Assuming a scenario, if it is, there is no force majeure, then of course there is one thing which you can rely upon, which we are again going to discuss, is a doctrine of frustration or doctrine of impossibility. So this is what becomes a major thing. But then again, when and how the courts have interpreted it, because just to give you at this point of time, doctrine of impossibility or frustration is something a very higher limit thing. It is not very easy to invoke those provisions. So that's why this force majeure thing becomes a very important thing in the contract. Plus, if you see, the purchase orders are generally, if you see now, for example, if a company is into contract in the laptop delivery, so generally they give a PO and they're done with it. So they just have a purchase order which is being signed, and that's how they kind of issue the laptops. Okay, give us the advance and I'll issue the you say 40 laptops. But then there is nothing which talks about what if the order is not given in time, what will happen to the delivery, what will happen if there is a delayed performance by either party, what will happen if there is the advance not received, or such things are not being discussed in the PO, unfortunately. And that's why this PO based contracts sometimes become a problem if they don't have elaborate conditions mentioned in the same. And of course, force majeure. Now, we see that there is no clause of force majeure, but there is also scenario where there is a force majeure, but like now we are seeing the pandemic, if there is no mention of pandemic or if there is no appropriate wordings in that, then of course we are going to see how difficult it is. Because one thing, guys, you will have to remember is contracts are the most important thing in the contracts is how it is being drafted. Because if it is being drafted correctly, then you will have the advantages over it. Because if the drafting is not correct, if it is vague, then of course the advantage which you can take out of the contract or the contract may not come to your rescue as well in such kind of scenarios. So now we are going to see what is force majeure and the doctrine of frustration and impossibility. So Varun, you can take the next slide. So what is force majeure? The force majeure thing, if you see in the Indian Contract Act, you will not find any phrase which is called as force majeure. So how does it come? So force majeure, if you see by the definition, now it has been settled, what is the definition of force majeure, plus various courts have held what is force majeure. But if you refer, say, for example, Black's Law Dictionary, then the force majeure event means an event or effect that can neither be anticipated or controlled. So these are the key things that if you can't foresee or you cannot anticipate. Now, if 6 months before somebody would have told us that there would be a pandemic and everybody would be staying at home, we would have been laughing at that person and we would have saying this person has gone mad. But today, if this is the scenario, so this is something, of course, nobody imagined that there would be such kind of pandemic. Plus, nobody imagined that the impact of this pandemic would be such that people will not be able to meet in person and hamper the industries. So yes, so these kind of things can be treated as force majeure as well. Now, what if we have to go further to understand what is force majeure or the typical examples? So the courts have generally agreed that strikes or breakdown of machinery or can be treated as force majeure. So for example, so here what is important is whether the party has any control over the particular scenario. Now, for example, fire thing. Now, you know there is a fire insurance. Now, obviously, if a company has not taken related fire preventive measures, then of course you can't say, oh, it is a force majeure, right? You have to, you know that, say, for example, you're into heavy chemical industry, like the LPG thing which has recently occurred. Of course, there is a strict liability and all thing which we are not going as of now into detail. But the thing is, if something is very certain and you have not taken measures, then obviously this kind of treatment or the benefit of force majeure may not be available. So for that, the important thing is you need to, if it is foreseeable. Now, for example, going after, if somebody, I really doubt if somebody would be able to take the advantage of COVID, even if you have now taken the advantage of COVID. Because today, COVID is not new to us. COVID, we know what are the issues regarding it, or what can be the probable things which now can occur after 6 months. So today, we are well aware of what is COVID and how things are. So maybe tomorrow, people may not be able to take an advantage of this COVID scenario. Of course, that depends upon the contract, like I told you, how it is drafted and how the terms are negotiated. So all the time you will have to remember that whatever we say, what is there in the contract, what is the language used will have to be checked, and it will may vary case to case basis. Okay. So that is a thumb rule which will be all together in the contracts and force majeure and doctrine of impossibility and everything. But again, if we go back to force majeure, it is something which is very vague. Now, if you see, there has also been a notification by Government of India where they have mentioned that force majeure, of course, it's an extraordinary event, and you can invoke the force majeure clause whenever it is a government contract which comes into picture. Of course, this has been considered. So Government of India has considered this pandemic of COVID as a force majeure event. and they have also notified that wherever there is a contracts in between government and parties involved. So that is how recently it has been treated. Then if we see further, okay, there, how is this doctrine of impossibility comes into picture and where force majeure come into picture. So now we have understood that there has to be a clause in the agreement or the contract which you have executed, and that contract should have, yes, you can go to the abridged thing, Varun. Yes, so this is a model kind of clause which I'm sharing with you, which is an developed by the International Chamber of Commerce. So if you see the highlights of this clause is that unless otherwise agreed in the contract between parties expressly, where a party to a contract fails to perform one or more of the, now here what we see is because of the lockdown, because of the pandemic, there might be that the other party is not able to fulfill. So like I told you, 1000 laptops are to be delivered, so the other party is not able to do because maybe the assembling of laptops has not been done. So here what is going to happen is the failure to perform. So this is a failure to perform. Now, though the party wants to do, but it is not able to do because of the lockdown. So this is a failure or a to perform, and it could be not having reasonably been expected. So like I told you, till before COVID, nobody expected. So this is the way you can say that, okay, this occurrence was not expected at all, so that nobody could take any measures for it, and that it could reasonably have been avoided or overcome. So this is a very important feature. So like I told you, maybe going ahead, if this is still a contractual clause in the contract, you may not be able to take the advantage because it's a known fact now, and you have to take the overcoming the risk. You have to take an alternative measures if still tomorrow COVID remains. Unfortunately, I wish it doesn't happen, but unfortunately, if it remains for still 6-8 months, 1 year, nobody will be able to further take this advantage unless, of course, there are really the reasons that it's in a containment zone and still they are facing issues, then of course. So this is one thing which you have to remember, that reasonably have avoided to overcome the effects of the impediment. You can go to the next slide, Varun. Yes, so this is, if you see, this is a typical list which has been given as per the model clause of International Chamber of Commerce. If you see, there is a war, civil, action of terrorism, act of authority, act of God, as we all know. Now, there were recently the Nisarga cyclone, and of course, Odisha and Bengal also faced similar kind of issues. So all these things, yes, this can be treated because nobody did foresee such kind of things are going to happen. So these kind of things, of course, can be treated as force majeure. So once we understand that, okay, this is a force majeure thing, and we can take an advantage of this force majeure thing, now what is next? Because just having in the contract is not going to suffice. There should be also an actions or taken by the parties for that respect. So what are the actions to that effect? So here the action is that you need to notify. Okay, notification of force majeure is an important thing. You need to communicate to the other party to whom you are obliged to perform that, hey, look, I'm not able to deliver the laptops and I'm invoking the provision of force majeure. So notification is a prime important thing when you want to invoke the force majeure. Okay, so notification is there. Then the question is, what is a period? Like when is the situation possible? Now, for example, if there is a like a tsunami or a Nisarga cyclone, or like what we saw, things were easy that there were a limited time period. So how the time period is calculated is generally when you are not able to perform. So say, for example, even today, if there is a lockdown or there is a containment zone which is being declared in a particular area, then the lockdown, even though like nationwide lockdown has been lifted, but the area where the company is located or where the area or the performance can happen of a contract is still under that purview. So here definitely you can invoke that, yes, this period is still a force majeure because we are still not able to perform. So here also importance is the burden of proof that you are invoking force majeure because things are impossible or things are not able to be performed at your end is a very key aspect. Okay, this is a very, the burden of proof of invoking the force majeure clause will always lie with the person who is saying, hey, I'm not able to do because it is a force majeure. So that is definitely there. Period, like we saw, what we saw is, if you have to conclude in one line, it will be till the time the performance is not feasible. Okay, because you will also have to take steps immediately to fulfill the obligation which you have uh, uh, promised to the other party, that I'll be fulfilling this particular obligation. Now, why this is important that force majeure should be invoked? The reason being, in most of the contract, this is an exception to pay damages. Okay, force majeure, why you should be invoking if you have, and of course the language is suitable and things like that, because this is an exception. Because why? You, once you invoke the force majeure clause, the liability to pay damages will not arise generally. The reason being, so say for example, the same scenario, if I have to deliver laptops, 100 laptops to the client customer of mine, then in this scenario, if I fail to do so, and if there is a negotiated contract properly, assuming, then here, because of the delay in performance, or because if I am not able to pay, I'm not able to fulfill the obligations, the other party can impose, can invoke that this is a breach of contract. Okay, this is a breach of contract. This is a material breach on your part. You have not fulfilled the obligations which you were supposed to do, and that's why I'm going to sue you for damages. So if you refer section 73, section 74 of the Indian Contract Act, it is all about damages or specific performance if you have to do, or if it is an injunction for that matter. So all these things will be of prime importance if you are considering this. So the moment you invoke force majeure, the damages thing may not occur even though you have agreed to a particular date, because there is a force majeure condition and you're not able to go ahead on that particular contract, which is not in your control, and which is obviously you did not see that it is coming, unforeseen, which could not have been foreseen, and reasonable. So all these things satisfying, now the other party will not be able to sue you for damages because of the force majeure condition. So force majeure thing should be not taken lightly, because the impact of the things which the other party can take advantage of, and that's why the notification thing also comes into picture. Okay, so this is kind of treated, like I told you, the exception to breach, and here ideally the damages will not arise, unless of course if it is now what had happened in the case of which we are going to see, we'll discuss it at that point of time. But Vedanta case, we'll see how things were different, where it was prior to the invocation of force majeure, you have already defaulted, and now you're claiming force majeure. So the courts have said, no, this cannot be the case, because you have already failed on your performances even before invoking the force majeure. So yes, if okay, fine, great. Varun has already taken us to the slide of Halliburton Offshore Services versus Vedanta Limited. So here, typically what had happened was the parties were already kind of, they were having issues. So Vedanta, so there were certain blocks, say for example, Mangala, Bhagyam, Aishwarya in Rajasthan. So the contracts where various performances and liquidated damages and advance bank guarantees were furnished by the other party, that is Halliburton. So the petitioner here contended that because of the COVID, I am not able to perform the contract, and he invoked so Halliburton invoked the force majeure clause. But when the court kind of reviewed all the contractual terms, the exchanges of communications between the parties, it was being held by the court that the petitioner first did not, so Halliburton first did not adhere to the deadlines. Okay, he did, the company did not adhere to the deadlines, and of course there was a breach. And after the breach is already being committed now because of COVID, you can't just take an advantage that, oh, this is COVID and I'm invoking force majeure clause. Because say, for example, if a performance was to be 100% to be completed by say 10th of May, and on the date of say 30th April, or even before the lockdown started, say 21st of March, or likewise when the lockdown was announced for a day. So at that point of time, even if only 60% work is completed, and which is not been foreseen that it will be completed by say 15th of April. So it is very clear that you could not complete the project which was there, and now suddenly you cannot hold that, oh, this is a force majeure thing and I'll be relieved of performance. So courts have definitely held that question as to whether COVID would justify non-performance. No. If something you had to commit it before COVID and you could not do, you cannot take the advantage today by saying, oh, it is COVID and I'm not able to fulfill the contract. So this was about Halliburton Offshore Services versus Vedanta. Then we are going to see quickly what is doctrine of impossibility. Okay, yes, so Varun has shared us a very proper side. Doctrine of impossibility. Now, this is something what we saw that, okay, what if there is no force majeure term in the contract? Okay, now you don't have any force majeure term in the contract was not drafted. Then how you're going to, whether can you invoke this doctrine is something is a challenge. And of course, like I told you, this is a very higher threshold. So if I have to understand what is doctrine of impossibility, you will have to refer section 56 of the Indian Contract Act. So basically section 56 talks about that if the contract becomes impossible to perform, which the promisee could not prevent unlawful, then it can be it becomes void when the act becomes unlawful or impossible. So basically when the act becomes impossible to perform, then you can invoke the doctrine of frustration or doctrine of impossibility, what we called, and compensation for loss through non-performance of act known to be impossible or unlawful. There is a provision to that effect. So must make, so if at all there is some unjust enrichment has happened, and like I've taken some money already from a customer and I am invoking now the doctrine of impossibility, but trust me, this is a very higher limit, which we'll see. But just for an instance, then if I've taken some money for as an advance, and I will have to obviously return that money. So that is also being mentioned in the doctrine of impossibility. But if you see, this doctrine of impossibility is being a kind of, the courts have been held because there are many celebrated cases in this. There is an energy watchdog case, we have Alopi case, plus there are so many case laws where, now I'll also give you a background to this and how doctrine of impossibility becomes really impossible to invoke. Okay, so the famous case about this is Energy Watchdog versus Central Electricity Regulatory Commission. Now, what has happened in this particular case? I'll give you a very brief synopsis of this. So this Mundra ultra mega power project was being conceived. It is in the 3 states like Gujarat, Rajasthan, and Haryana. Okay, so here there was a bidding tariff for sale of power was there, and bidding process took place. Now here Adani and Tata. So what they did was they quoted a non-escalable tariff. So that is, they can't escalate their prices. So that is a fixed kind of price which they have quoted. Now what happened in the meantime, this was the major component. Of course, there was an increase in the coal price. So there was an Indonesian law which got changed, and that's why there was a increase in the coal prices. Now what happened is these companies had executed power purchase agreement. So that is called as PPAs in the whole case. Okay, PPAs were being executed. Now here this PPA did contain, like I told you, non-escalation tariff related clauses. Now because the coal price got increased because of some change in the Indonesian law, the parties applied that, okay, the doctrine of frustration be invoked because the prices are very high now. Now it is not feasible, and it is not kind of possible for the company to further abide this contract. So here what happened was, the Supreme Court did held that this doctrine of frustration can't be invoked so easily. This price, if there is a hardship which is being faced, or a price escalation which is being faced, then you can't just take advantage of this doctrine of impossibility. So that's what I'm saying. The threshold is very high on this. Even this case, it was being held that just because there is a economic position which is not, the players are not competent to now face the prices. But the court said, no, it was the agreed contract. You knew that there is a non-escalation tariff which is being mentioned. So now you cannot suddenly go back, because the contract is what you have to travel within. So if you have agreed to it, now you cannot invoke the doctrine of frustration or doctrine of impossibility. So this was the famous case. So no compensation, the application was dismissed that no, you cannot get out of the contract. You cannot make this contract void just because it is now not possible for you to help the customer with a agreed tariff of electricity. So that is, you can't go or exit out of the contract because it is not possible for you to supply the customer at a given rate. So this is the famous case. Also, this is again been highlighted in Alupi Parshad and Sons Limited, which is on your screen right now. That if you highlight this, if you see, the Act does not enable a party to a contract to ignore the express covenants thereof and to claim payment of consideration for performance of the contracts at rates different from the stipulated rates on vague plea of equity. So if you don't have force majeure in the contract, then what is left to you is, if at all, if you are able to invoke the doctrine of impossibility. But like I told you, if you see this, generally what are the thresholds for invoking this is the subject matter of contract is destroyed. So say for example, there is a stadium and because of some like tsunami or something, the stadium has been collapsed and there is nothing now, destruction of entire property, and now you can't sell it, is something may be treated. Or say for example, if it is a personal contract, like a painter wants to sell a painting to, so A agreed to sell a painting agreed to buy a painting from a painter B. Now, unfortunately, if B died or he is now unable to paint, then maybe the doctrine of impossibility can be invoked, because it is a personal services of that Mr. B who is a painter. So here may be possible. So if you see, the thresholds are very high. Just because of change in price. Now, whether the question is, this is always a debated question, that whether this doctrine of impossibility or frustration can be used in COVID. Now, I know all of you can definitely answer. This is not a permanent hamper of the contract, right? It's just a temporary period. So in invoking, unless of course the facts are that relevant to that effect, but just because there is a lockdown and I'm not able to fulfill the obligations, the courts may not entertain this as a reason, because like I told you, the threshold should be really very high to invoke this doctrine of impossibility. And even if there is a hardship, there is an extra payment, there is an extra issues to the vendor to supply. Now, for example, if it is Pune or Mumbai, which is under say exactly lockdown, and if the goods were to be delivered through Pune, so if it has to, now there is a supplier sitting in Delhi and the goods are to be delivered in Chennai. And say, for example, Mumbai was the route through which the goods are to be delivered. So the courts will say, and this is the safest and the cheapest or the maximized route from a price point. The courts, and if you say, oh, no, I want to invoke the doctrine of impossibility, it may be difficult, because the courts will say, no, you go to Kashmir, go any other route and deliver the goods in Chennai. We are not bothered how it is cost effective or not, or whether it is an issue to you or not. You have to fulfill the contract. You don't have a choice. So such kind of things have happened and the courts have held that it is a very higher threshold. Okay, so by this now we'll go to some specific cases which have been the jurisprudence. I'll touch quickly on that and I'll go to the M&A aspect. So Varun, you can take the next slide. So these are the jurisprudence which we have got. So there is a case about a tenant seeking shelter under COVID scenario. So this is a case where invocation of force majeure can be done. So this was a plea by a Khan Market tenant in Delhi, where he wanted to invoke the force majeure clause. But again, the Delhi, now there was nothing contract or a lease deed which everybody had. So in this certain scenario, so what happened was the court held, no, you can't invoke the force majeure clause. You will have to pay the rent. So that was being, so waiver of payment of monthly payment was being asked by this tenant of Khan Market area in Delhi, but it was being rejected by the court. So this was the particular case. Then we'll go to the next. So because if you see, there is a Transfer of Property Act which also comes into picture. So that also has to be clear. Again, the thresholds are very high when it comes to impossibility. So the next is, of course, this is a important which I want to touch upon is the ficus case. This ficus case is of prime importance. The reason being, there have been a lot of issues with reference to the contracts, employment contracts. Okay, so the employment contracts also, if you see, these are not very easy. The welfare legislation is considered, these are considered under welfare legislation. So we have seen that the Ministry of Home Affairs had issued a circular that you have to pay wages to your employees and you cannot rule out that even if they are not coming to the factory or the office. So here there were several writ petitions which were being filed in the Supreme Court, PILs which were being filed. So we have got a recent judgment on that. Of course, it is still at a nascent stage that the Supreme Court held that no, you will have to work out amongst them and between the employees and companies, and then only you can sort out the differences, what companies can be payment, because after 50 days, of course, this was being relaxed that no, there is no requirement to pay. But that 50 days, the advisory was being issued by the Ministry of Home Affairs. So that was, the courts have recently held that no, you will have to settle it amongst yourself by negotiation. And if not, then of course, the labor authorities can come into picture. So that is what it is. So going ahead, what you have to, the key takeaways for the contract related are, you will have to review the important contents. Then of course, reassess the rights and obligations. You will have to check what are the obligations. Ideally, you should take out the contracts, check what are the key contracts, what are the rights and obligations, analyze the impact of COVID going ahead, because like I told you, how things can be different, how things can be done in an alternate way is something you will have to take care about. Like I told you, if there are going to be any price fluctuations and if you can cover it in the contract, great. But that is also one thing which you should be remembering. Then I'm going to go to the merger amalgamation related impact. So this is what we discussed. Yes, Governor, you can go to the next slide. So in case of mergers and acquisitions, there is this MAE similar to what we discussed about force majeure. This is a clause in the M&A transactions. And if you see, the provisions typically deal with any business impact created, a financial condition, an operation of companies have been badly affected. Now, if you see, I'll take questions later on, okay, guys, so that I complete all the stuff which I have, and I'm happy to take the questions, okay? So if you see, now again, this goes from a drafting perspective, that if you are into a deal, how this MAE or MSC clause has been drafted. Because some cases, they have exclusively excluded things like pandemics and epidemics. Because again, what is the impact? It might be like, for example, travel industry is deeply affected. But say essentials industries are not at all affected. They are properly functioning. So if an M&A deal is happening in a essential related industry, So I don't think you can invoke this clause, right? Because there is no impact on your industry, there is no impact on the company at all. Just because there is a pandemic as a whole, you can't invoke because your company is up and running. So such kind of things has to be really checked for. So these are the standard clauses which are there in the entire gamut of material advanced material adverse change or a MAC clause. The provision typically state with respect to some or that how disproportionately adversely affected. So like I told you, if some industry may be affected, but your company may not be affected because it's not in a containment zone and everything is going super normal, or you're in the green zone. So such kind of things definitely come into picture. So what is if you see what are the deals which have been impacted, and these are the very recent thing. Varun, you can go to the next slide. So the deals which have been recently paused, if you see the US printer maker Xerox Holding Corps wanted a high hostile cash takeover of HP, but they could not go ahead on that because of the pandemic, and this has badly impacted the deals. There are two aspects, or if you see the M&A deals in general, M&As are getting impacted either positively or negatively, or they are halted. So these are the three categories. Now, like I told you, essentials, everything is going super great. Pharma, it is like booming up. So pharma industry, M&As, I don't think there will be an issue. Plus, we also are seeing Reliance acquisitions are going every day. We get a news that there are a lot of acquisitions in the Geo. So many companies are buying stake in the Geo platforms. So some companies, if you see, are not at all affected by the M&As. Like M&As are not affected by the COVID scenario. But we'll also see the deals which are going SAR, which is the next slide. So if there is recently, like just 2 days before, this was a reported case where the Yatra company, if you must have been aware of. So this Yatra company, Ibix Inc. had signed an agreement in July 19. So that was the agreement when it has been signed. But if you see, the travel industry is badly affected, and there is no recent future to this, that when people are really going to travel. So such kind of things, and that's why if you see the deal is going through a rough patch, and where there is a counter suit which is being filed, other parties suing for breach, and they are willing to terminate, and the merger agreement where the other party is saying, threatening to file a counter suit pending merger agreement. Now, why we don't have much of jurisprudence in the M&A deals? Because if you see, there is an arbitration clause most of the time. So the arbitration clause gets invoked, and then there is no much of jurisprudence available, especially on the MAE or the MSC clause. There has been a recent case which was being mentioned in the US, but if you see, the thresholds were super high. So there is an Delaware court judgment of Acon Inc. versus Prisoners Kabi AG. So where the acquirer was allowed to walk away because it was being mentioned that the business fell off a cliff, and there was super decline in the 25% decline in the revenue flows and all. But if you see from an Indian context perspective, we have again got a Nirma case, but these kind of things did not sail through enough that, okay, because this will come in the known risks and how the things are affected. So that's why in terms of M&A, things are going to be different for each sector wise, that how sectors are being performing, and depending upon that, things are going to be different. Okay. Now we'll just quickly go through, and I'm happy to take the questions after this. What are going ahead safeguards for M&A? And Varun, you can take the slide. Yes. So these are the takeaways from what diligence would be required, that how do you kind of take care of the acquirer should familiarize himself basically with the business, what are the weaknesses, impact which is going to be created, and the sellers on the other hand may include some specific information that the deal, or they can put some kind of what is a closing timeline, because the more it takes time for a deal to get closed, then of course with the pandemic and things not going right, it might create an impact on the deal. Plus, if you see, there can be a termination fee or a break fee which can be agreed upon between the acquirer and the target the companies involved in the M&A, that what can be the termination fee if somebody wants to back out or get out of the deal. Plus risk management things should be there. Like I told you, going ahead now, COVID, taking advantage of COVID may not be possible. It could have been taken earlier, but now if you take that, it might not be that feasible because it's a known thing now, and you should be forcing what the risks are to your business and how you're going to navigate out of the risk and the contracts which you have entered, and what are the alternative ways by which you can function, or the price points. So the ideal way, like if I have to summarize all these things, practically these things have to be negotiated, right? Going to a court is not an easy job, and like I told you, the language of the contract becomes very important. So if I have to summarize this, force majeure can be invoked if you have a good clause in the agreement and you can take an advantage of it. Doctrine of impossibility, like I told you, is require a very high threshold. So invoking that may not be that easy. You will have to negotiate whenever things are not right in your favor. There are other parties, because see, you can't just get out of lease, right, by saying, oh, I want to terminate the lease, because there are stuff lying over there. There are other, plus there is a business relationship between the parties as well. So things are not very easy when you look at from a business perspective versus a legal perspective, because we are talking all about legal perspective, but there's also one thing which all the businesses has to consider is a business relationship, be it your client, be it your supplier, or be it your landlord, or be it your employee for that matter. So all these relations also come into picture. The reputation of the company also comes into picture. So this is where there is a negotiation, there can be a mediation, there can be arrangement between the parties. Both the parties are going to suffer, because it's not just I'm suffering, right? The other party is also going to suffer. So this is the presentation from my end, and I'm happy to take questions and as per likewise. Yeah, thank you. Okay. So I see questions right now in front of me. What impact does COVID-19 has on commercial contracts between government and a private company? As you pointed out that commercial hardships are being faced. So in the light of the same, can a representation be made to relax the terms and conditions for the time being? So like I told you, the government has already said that there is a force majeure clause by a notification. So that can be definitely being invoked, and things can lie accordingly. Plus, this can be, now I would just want to refer here, I'll not go into details of it because of the paucity of time, but this is, there is a Singapore government has really, or the country has really brought out a great model on how contracts, because this contracts is going to be faced by each and every company, if I have to be very clear about it, because the issues about supplies, about the presentation, about the fulfilling of obligations, the impact on finance is super great on most of the companies, if not all, either or the some area. So here they had brought a very good model. You can also go through it, where they have brought an elaborate law that how this COVID scenario can be dealt with reference to contracts. Unfortunately, we have got something in the notifications by the MHA. Then we have got competition law saying. Then we have got Companies Act saying something. So there are various ways by which this COVID scenario is getting captured for various perspectives. But we don't have a centralized thing where you can look for. Okay, so yes, but you can invoke. Then there is one question: how a failure to provide notice is treated by courts, whether relief will be provided or not, simply because the contractor could not provide notice. Okay, so like I told you, the notice has to be ideally given. Now, if you don't fail, how the other party is going to understand, right? If I don't give the notice that I'm invoking this force majeure, then how? Because like I told you, there is a threat that the other party may sue you for damages for not fulfilling your obligations. So here it becomes very imperative that you give notices. So that is essential for giving notices. Then if one has to bring doctrine of frustration, this would only go towards termination of contract, correct? Is there any case where such doctrine was partial non-compliance of contract? So like I told you, the doctrine of frustration is ideally being invoked that to exit out of the contract, right? to get out of the contract, that it is impossible now to perform and I have to get out of the contract. So partial thing is not seen in the court of law or the cases which we had, be it the energy watchdog case, there are Alopi, there are n number of judgments, even the English judgments on this doctrine of impossibility. But if you see that partial non-compliance may not be, either that would have been resolved among the parties and it would have not led to the kind of getting into or obtaining the route of the legal route. So that is not seen. It is either I want to exit out of the contract. One question, so if a force majeure or doctrine is invoked, does it sets the contract aside or it simply make it voidable or something else? So understand, force majeure is a issue that you are not able to perform for a particular period, right? So it is not, the contract is very well there. It is only you are invoking a provision. So it is a very well valid contract. So it is not that, now if there is a provision in the contract which says that now the performance is not being, like you are not able to see the performance by a party for say 6 months, and that gives a right to terminate the contract to the party, then yes, that can be invoked as per the language used in the contract, that yes, 6 months the party is not able to perform and now I'm invoking the termination contract, I'm invoking the termination provision and I'm going to terminate the contract. So that can be very well possible. What is the difference between doctrine of frustration and law of hardship? Whether law of hardship. So doctrine of frustration, I guess I have taken it at length. So it is, like I told you, the threshold is super high. In order to frustrate, it has to be the examples which I gave. Okay. If there is an arbitration clause in M&A contract, eventually dispute arises, then which forum will have jurisdiction to adjudicate, NCLT or arbitration tribunal? So generally, if now, even there was a recent case of an IBC as well. Yesterday, I guess couple of days back, I just try to remember the citation where again it was being referred by the courts. If you have an arbitration clause, then the parties first should invoke that arbitration, unless of course it is an operation mismanagement or the things which arbitration can't be taken care of or cannot be used, then of course it makes a difference. But if, and that's why if you see we don't have many jurisprudence on MAE or MSC clauses, because most of the things get settled through arbitration and obviously the awards are not very public. So yes, it will be ideally if it is about price related things or if it is an arbitration clause, most of the times the court will say you have agreed as parties to get into arbitration, so now you will have to first resolve that. And if of course if there is a issues in the arbitration like challenge or things like that, then of course the courts will have the route. Yes. Okay, I guess I've completed all questions, or is there anything left? Or
yeah. Thank you, Deepti, for this wonderful session on impact of COVID-19 on contracts as well as merger and acquisition. There are certain questions that we had received prior to the webinar. One question is related to the force majeure. One of the participants has asked that a force majeure event, as if the COVID-19 goes around 3 months or 4 months, because now government has also opened the lockdown. But the impact of this event has been prolonged because the impact is in the whole economy, and it's a struggle for small companies as well. So for how long this the advantage of force majeure can be taken by the industry?
Yes. So to answer your question, like I told you, till the time it is, the party is not able to perform. So like 3 months we had the lockdown, and afterwards to start the operation, say for getting the raw materials which were supposed to be, you need to get it, then the laborers are going to join, plus there are labor restrictions, like say for example 50% can work or likewise. So till the time it is reasonable for you that you are not able to perform, you can kind of invoke the force majeure clause to the extent it is not possible for you to perform. So like for example, if it is the recent Nisarga, that the entire office is being lost because of the Nisarga, then till the time you set up that office and you get back to the conditions, you can kind of invoke. But yes, that can be sometimes disputable by the parties as well, that to what extent can be reasonable and to what extent it can't be reasonable. But till the time you kind of normalize and you can start your operations in a reasonable manner, I guess till the time that force majeure can be invoked.
Sure. Regarding the M&A and COVID-19 interface, uh, one participant has asked that should the transaction documents be structured so as to include pandemic to constitute a material adverse effect?
Yes, ideally, yes, because if that, like I told you, the M&A or be it any force majeure clause, the language of the clause which is being structured is going to have a supreme importance, because we have the principle of ejus dem generis, where if what are the phrases which are being used, whether that is in conjunction with that. So if there is no mention of pandemic, then whether you have that words like, for example, the act of God or government restrictions or something like that, which can point out that this can be the scenario. So the wordings are going to be of prime importance. If there is a now we saw that there were recent deals where they have excluded pandemics. So what the parties are willing to accept it is going to be of prime importance, that whether they want to include that particular thing or whether they want to exclude that. Yes.
Yeah, because we have observed that now government agencies are also uh, working from home,
True.
and there is a lot of delay in getting approvals from different authorities, because in an M&A deal we have to get approval from various authorities in different sectors.
Absolutely.
So don't you think that the transactions, because it also depends on the at which stage the transaction is.
True.
So we can go for electronic signature and everything could be done electronically, because it's a strategic decision, because the delay in merger and acquisition has a great impact. So what is your view on this?
So yes, because see, mergers and acquisitions are not that simple transactions, as we all know. There is lot of steps involved, right from the due diligence, potential acquisition, definitive agreements. So at which stage the M&A transaction is, whether the definitive agree or the conditions precedent have been fulfilled. So shareholders agreement has been signed. So at what stage these things happens is also of very importance, and how the drafting has been done, what is the intention, and like I told you, what is the corresponding impact on that particular company. Because like I told you, if it's a pharma company, they're fully operational, then things may not be you can't invoke such clauses. And if you see, the jurisprudence is also, if you see that it's not very easy to get out of a M&A deal if you have signed everything. If you see there, the Nirma case also, it's not that easy. Unless there is some regulation and things like that, then only you can get out of the contract. The Delaware case which I mentioned you, it's, I guess, one of the case or very rare cases, and going ahead the jurisprudence may develop, but what may come into public knowledge is also very prime importance. But yes, at what stage and what language is going to definitely matter, and plus what is the corresponding impact on that particular industry is also a case of which has to be looked into, and what disproportionately adverse effects it has created, that will also be considered.
Of course. So few of questions are there on chat box.
Okay.
Let me see them. Yeah, so there is a question from one participant that if contractual employees who have not completed 10 years of employment but subsequently dies, can the EPS be made applicable based on the COVID-19 ground?
Okay, I guess this is a bit different question from the context. But if I have to answer this, contractual employees, now again, there are various ways by which you see how the employees are governed. Okay. There are contract employees who are not on the payroll of the company. Then there are employees who are treated as workers as per the definition of the Industrial Dispute Act. So that is one thing. Plus there is like the people who are managers and above, what we typically called as white collar contracts. they are again governed by the contract of employment. So the workers contract employees and the managerial and above, where they don't fall under the definition of workmen and they are not governed by the Industrial Dispute Act, things are going to be different. So here, if it is about a contract employee, then the principal contractor, so it's like the principal I am employed with somebody else, but I'm on the working for some other company, say HP, I'm working but I'm on the payroll of ABC company, then I'm contract employee for HP, but then the contract is between ABC and HP. So here things will be, who is my principal employer and who is my who I'm into secondment into, so that is going to make a difference. So whether the principal employer is generally held liable for all these things, even, and of course the person who is having employment with that company will also come into picture. So generally, if you see the contract, and now there are also layoffs which are happening around most of the industries. Again, this will be typically governed by the Industrial Dispute Act, so that comes into picture. Yes.
Yeah, because there are a lot of changes also now are going on as a reforms because of the COVID-19 by the government. So what is your views as to the post COVID-19 impacts on the corporate law sector generally? Maybe many deals and corporations now are struggling because of COVID-19 impact on the economy, as well as the changes, because some of the changes has not been welcomed.
True, true. So if I see as an industry perspective, see COVID-19 is going to change the outlook of how business is going to operate as a whole. Like even from the real estate perspective, what we are seeing is if people are good at working from home, then what is the need of a hanky-panky premises and stuff like that. Plus from a manufacturing setup, so there is a lot of pressure of cost, because the sales line, sales or the top line, what we call, that is the company which earns sales and revenue, is deeply affected by the 3 months. Its companies are deeply affected by it. Plus the contracts on which the client contracts, they may not be in a position. You may be a great company, but the clients may have really deteriorated because of their business conditions. So yes, it is going to be a tough time for as an industry as a whole because of the COVID scenario. And all the way the costs is going to be something, and negotiations would be now more or a more dialogue would be created between the vendors, be it the customers, between the employees, and like everything can't go to a court of law. So somewhere midway things have to be taken care, so that both the parties are in kind of a win-win situation, kind of, because it's very again not difficult, it's very difficult to bring that win-win situation.
Yeah.
But that's what is might be seen further, is what I'm expecting.
So with this, we come to the end of today's session. I'm very much thankful to you for sharing your valuable views on very, very important topic in the corporate law. I also thanks to all the participants for being with us and spending time with us on Sunday afternoon. I request Varun to give vote of thanks.
Varun, you're speaking on mute. Yeah.
I would like to extend our heartfelt thanks to our speaker, Advocate Deepti Dole ma'am, for having accepted our invitation to conduct this session. I'm sure that each one of us who attended this would have reaped out the maximum benefit of your sea-wide experience and insights, ma'am. We strongly look forward to more strengthened future collaborations and tie-ups. Also, without failing to mention this, we were elated to cater all our guests who joined this session and also invite to our future sessions. Though we mark an end to this session, but certainly we have embarked on a future togetherness where we shall strive to attain knowledge. Once again, I would like to thank all of you on behalf of Institute of Law, Nirma University and Team CCLS.
Thank you, Professor Amit. Thank you, Varun and team, and thank you to all the participants. Really glad to have you. Thank you so much. Bye-bye. Take care. care.
And thanks to Digant Bhai also for giving administrative support.
Yeah.
And special mention to Palak Dheer, who is the secretary for CCLS, and Abhishek Sadhwani and Chinmay Jain and Harsh Garg.
Sure.
Yeah.
A great round of applause. Thank you, guys.
I
Thank you.
hope everyone enjoyed. Thank you.
Yes.